Did you know that the Florida family courts can calculate child support and alimony based on what they think the party's income should be, not what it actually is? This is called imputation of income. The party who's asking for the court to impute income to the other party has the burden of proof that the other party is voluntarily under or unemployed. In other words, they are able to work some kind of full time employment, but they are choosing not to. For example, if the party is physically or mentally disabled to the point that they are unable to work a full time job, the court cannot impute income to them. That voluntariness is very important. Unemployed is pretty self explanatory, but someone can be underemployed if they are able to earn a substantially higher income than they are currently earning, but they are choosing to take a lower income. If a party is fired from their job, they are not voluntarily unemployed, right? But it is then their obligation to do their due diligence to secure new employment at the same or a substantially similar income. And if they do not do that, then the court can also find them voluntarily unemployed or underemployed. What can the court impute? What I often see is a full time minimum wage employment salary, assuming they're not making that already. That being said, technically, if there is no information about the parent's income or their earning capacity, the Florida statutes actually say that if a parent refuses to provide their financial information, they fail to participate in the proceeding, or they fail to supply adequate financial information about their situation, income shall be automatically imputed to that parent. There is a rebuttable presumption that they have an income equivalent to the median income according to the Census Bureau. If they can prove that they have an ability to earn a higher income than the median income, right, then the court can actually impute an even higher income based on their historical earnings and earning capacity, recent work history, occupational qualifications, and prevailing earning levels in the specific community in which this imputation is taking place and these parties reside. That means there's a lot of evidence that is needed here. If you're asking for an imputation that is higher based on historical earnings, right, and earning capacity, you are going to have the burden of proving all of that information. If the court is going to do this, they have to make findings of fact in the order that there is substantial and competent evidence in the record that the employment or underemployment is voluntary. And they have to identify the amount and source of the imputed income. And this has to be through evidence of income from available employment for which the party is suitably qualified by education, experience, current licensure, or geographic location. The statute says, with due consideration being given to the party's time sharing schedule and their historical exercise of time sharing provided in the parenting plan or relevant order. One thing to note is the court actually may refuse to impute income to a parent who is more a stay-at-home parent or has to stay home with the children. So if you are a stay-at-home parent and or you are getting a majority of the time sharing, you can ask for the court to refuse to impute a higher income to you, even though maybe you're physically able to work a full-time job. You're not, because you are caring for the children a majority of the time. That being said, there are websites that you can run the Florida child support guidelines for yourself. I recommend running various scenarios, imputing income to you, the other party, actual income, different types of time sharing schedules, because the child support guidelines are based on the total income of both parties, and then it allocates financial responsibility and then calculates based on the percentage of overnights and some other credits and factors. Sometimes, if a higher income is imputed to you, those incomes are going to be added together. And if the other party still has a higher income and or less time sharing, that actually may increase their child support obligation. It's kind of complicated. It doesn't always, but I would say run the guidelines and figure out what the best scenario is for you before you start discussing imputation or whether the court can and should or how that all should work. And as always, I highly recommend you speak to an attorney to have a consultation about your specific situation. And I also wanted to say the court can actually also impute income to a party for alimony purposes. I have another video that I did about alimony. I also have another video I did about the child support guidelines. You check out my profile and watch those other videos if you want information about sort of a general overview of those topics. But I did want to dig into this imputation topic because it seems like a lot of questions keep coming up about it. So hopefully that helps.